I'm an attorney in Philadelphia. I do litigation, general corporate work, and business bankruptcy. And this is a number in a series of talks that I'm giving to you out there, the public, on various issues in the law. Today, we're going to speak about business litigation, or mainly just litigation in general. Litigation starts with the filing of a piece of paper called a complaint. It's where one person or one company says to the other, "You've done me wrong, this is what you've done that's wrong, and this is what I want in return for what you've done to me." That gets served on the other party. They then have an opportunity to respond. If the complaint is really wrong, if it's fatally deficient, you can file what's called a motion to dismiss the complaint. However, normally that's going to be denied, and at some point you need to answer the complaint, and you just say your side of the story. This is why I didn't do what you say I did, or this is what I did, but I don't owe you what you want because of this reason or another. After the complaint and answer are filed, the parties engage in what is known as discovery. Basically, discovery is simply fact-finding. It gives both parties the opportunity to learn about the other side's case. There are different types of discovery. There is oral discovery, which are depositions where you bring the other side in, or witnesses, and you ask questions under oath and they give answers. There's also written discovery, which is request for production of documents, which is self-explanatory, where you're just getting pieces of paper from the other side. Interrogatories, where you're asking them to explain in writing their positions, and requests for admissions, which is where you sit there and say, admit or deny the truth of a particular statement. Once all of the discovery is done, then there's an opportunity for what are called pretrial motions, such as a motion for summary judgment. A motion for summary judgment says to the court, there are no issues of material fact, and I am entitled to judgment as a matter of law. Now, these are not granted that often, but if the case is very, very clear, there's no reason to go to trial. If it's denied, then at some point you do go to trial, and you're either going to have a trial in front of a jury if you've made the demand, or what happens more often, it's called a bench trial, which is simply a trial in front of a judge. That's the end of the litigation process. This is Rob Bovarnick,